Good evening, Justin. Welcome to the webinar on entrepreneurship being done through the auspices of MyElectricalCommunity. Perhaps just a brief on MyElectricalCommunity, Justin, and for our listeners, MyElectricalCommunity is a peer-to-peer business and social network for individuals with an electrical background. I've started doing the interviews essentially with people that have started their own business, or someone like yourself that has been in constant contact with individuals that start their own business through the work that you do in terms of the IP and legal and patent attorney work that you do. For our listeners, Justin, are you able to give us a bit of a feel and a brief for your journey to date?
Yeah, sure. It's a pleasure to be here.
Welcome.
Yeah, so I'm a patent and trademark attorney, focusing on the patent side mostly.
Mm-hmm.
And I've been in that in that profession for over 10 years now, helping various people protect their technologies. Mm-hmm. Before that, for many years, I was a researcher in the photonics area. So I worked on various optical devices for telecommunications. Mm-hmm. Mainly, ironically, trying to replace electronics, but obviously working very closely with those sorts of electronic technologies, and with a lot of similarity in modulation formats and the like. So a lot of overlap between the various optical and electronic technologies. Mm. So yeah, that's basically my background.
And you've done your, I think, a couple of undergrad degrees and a master's. You've been, I guess, at the early stages, plugging away, doing a fair bit before you even started your work journey.
Oh yeah, sure. Sure. I mean, I've got several degrees, like most patent attorneys. I've got a degree in intellectual property law, which is a specialist law degree. Mm-hmm. So that makes me a specialist in intellectual property and basically totally ignorant in every other area of law. So don't come to me if the police come knocking. I won't be help.
No, you're being very modest about that.
Yeah.
Justin, in terms of for a layperson, what's the difference between a patent and a trademark?
Yeah, well, there's a very big difference. Basically, a patent protects a technology, mm-hmm. usually protects a function. So it's great for protecting electronics and electronic products, mm-hmm. or mechanical products or electromechanical products. Mm-hmm. They protect also matter like chemicals or new composite materials and the like. Mm-hmm. And that's very different from a trademark, which is basically something which is used to differentiate the goods and services provided by one person from the goods and services provided by another. So things like Coca-Cola, Armani, Holden, those are trademarks, and they're protected by registered trademarks. Mm-hmm. There is another difference in that patents can only last up to around 20 years. There's a bit of variation in there, whereas a trademark can last indefinitely. So in the long term, you can't ignore trademarks. Mm-hmm, but companies like Toyota, which are basically technology companies, manufacturing and technology companies, they rely very heavily on trademarks for their business, and a lot of consumer product companies rely very heavily on trademarks. Extremely important to them, and they're often undervalued. However, having said that, usually when the entrepreneur has got an idea or a company has just started, they're really about developing new technology, and at that point it's probably more important to have patent protection in the early days. But as the technology matures and their reputation in the marketplace consolidates and develops, that goodwill is worth a lot. And it's very important to protect that, and that has great value.
So using the the example of Coke that you mentioned, the words Coke would be protected by a trademark, but the actual composition of what goes into the drink, that special formula would be patented. Is that? Yeah.
No, the special formula for Coke is not patented.
Right.
The thing is, not everything's suitable for a patent, and a recipe is one of them. You can't patent a recipe.
Right. Okay.
So they actually protect that by secrecy. So no one, or very few people actually know the secret for Coca-Cola, and they guard that very closely. It's not just Coca-Cola that can use that strategy. Technology companies can use that strategy too. So, for example, while they're developing their product, while they haven't released it, they should, consider very strongly, very seriously, whether secrecy is the better short-term strategy than filing a patent. It may not be, but it may be. Especially if you haven't got much money, you might just want to keep things secret for as long as you can. Some things are always better to try and keep secret, and one of the big reasons to do that is because a secret can potentially last forever.
So I don't understand. What do you mean, secret? So is that
exactly that
a really defendable sort of thing?
That there are legal rights around secrets, specifically confidential information, and there's actually an area of law called the tort of breach of confidence. So if someone tells you a secret and it's confidential, and it's clearly confidential, and that secret has got value because it's confidential, and you take steps to keep it secret, you can actually demonstrate that you've taken the appropriate steps to keep it secret. And you actually can take legal measures against someone who breaches your confidence, and you can actually be awarded damages for that. But it can actually be quite hard to enforce, because how do you prove what you've told someone? So you have to be very careful about that, and you have to. That's why confidentiality agreements are very important, and having good records of what passed between you and other parties.
Yeah, sorry, was going to say something?
I guess the other thing is that secrets can have value. So you can, you can sell a secret. So it's not. You can, it's not a silly strategy, keeping things secret. It's not appropriate in all circumstances, and in many circumstances it's not, because you can reverse engineer products, and then you can't keep it secret.
Absolutely.
So if you can reverse engineer a product then that you want to keep secret, then that's the wrong strategy. Okay.
A lot of the listeners to this recording would be at the early stages of their entrepreneurship, their business careers. At what stage should someone go out there and take out a patent, a trademark, have it classified as a secret would be, I guess, the most cost effective. But in terms of patent or trademark, is it at the conceptual stage, around the time that they have developed a proof of concept and they're going and taking the round to other people to get their feedback on it? What stage should they really, take out their patent or trademark?
Well, I think let's do the easy one first, the trademarks. I think most companies can set aside the trademarks, registering trademarks for a while, because that's really something you do when you're ready to go to the market. And you're ready to build a reputation and develop that brand. So unless you're particularly got a brand in mind and you want to be absolutely sure that no one's going to take it, then it's probably okay to hold off on that and just to see what happens. Having said that, they're not very expensive relatively, so but I think you can set that aside for a while. Patents are probably much more important to consider. That's not to say that you should definitely get them. And the other thing is that no company is going to be the same. Every company is going to have different requirements. The market's going to be different. the time that's going to take to develop the product is going to be very different. The commercial situations are going to be very different. So it's hard to give blanket advice, and people should get good advice early on this very point. But there are some general patterns that you can follow. The big one is that most entrepreneurs who come to see me for a patent want to do so for one reason, and that's to get investment. Investors are usually insistent on patent protection if they believe that patent protection is suitable. And there's good evidence out there, good studies that I've seen which show that software companies, for example, who have got patents attract a multiple of the amount of money. And they're much more likely to attract the money in the first place. And what's even possibly more important is the quality of the investors is much higher. So they can assist in the growth of the company. So patents can be very useful when you're trying to seek in investment. But there's other issues around that too. Money is the big one. So a lot of people don't have much money, so you have to be very careful. If you patent too early, you can run out of money. So, and you expose yourself and give you a false sense of security. So you should consider, how long can I keep.
What do you mean? You've said going in too early and expose yourself. Could you just explain?
Sure. If you file a provisional patent, for example, then you might think you can go and tell everyone about your invention. But the thing is that when you file that provisional and then tell people about your invention, you really locked yourself in. What that means is now you're on this ride that you can't get off. Basically, you have to keep going with the patents if you want to seek patent protection, and the deadlines are already set in stone by statute. So you keep on have to chase these deadlines, and so the decision is taken away from you somewhat. So you have to be a bit wary about that. If you go in too early and you don't have enough money, then you might file your provisional, but then find you haven't got enough money to follow up, and you lose your protection. And you've told people about it, so you've shot yourself in the foot. So that's a bit of it's an issue.
Right. So how does this provisional patent work? How long is it provisional for? And does a provisional patent protect you as an original patent does? So what's a provisional patent anyway?
Yeah. So a provisional patent is an entry point into the patent system. It's a low cost entry point into the patent system. It actually does not provide any protection of itself at all. But what it does is something very important. It provides you with what's called a priority date. So when you file the provisional application, you're given a priority date, which is the date of filing the provisional. That means that if you file subsequent applications, you can claim priority from your provisional, and you can claim the priority date of the provisional. So if anyone else tries to file a patent for your invention after your priority date, you have priority over the other people. So in effect, it's saying that this is what we're seeking, and no one else can seek it until we give up.
Okay, fair enough.
So
right.
That's a very important. It's a good way to start, because you can file the provisional. It lasts for 12 months. You don't have to spend too much money in that 12 months. On sort of budget between $5,000 to $10,000, depending on the invention. It could be a lot more if it's a complicated invention, but that could be. It's a good starting point. And in the meantime, with that provisional, you can go and speak to investors, and that your invention is somewhat protected, and you can attract money with that patent. Yeah.
So you mentioned the provisionals about 5 to 10 grand. It could be more. but then the actual patent is a lot more. So is the provisional less expensive than the actual patent?
Yeah. I mean, the cost to obtain. So there's a real difference between a patent application and a patent. So you file a patent application, and then if the patent office examines it and likes what it sees, it will accept the application and grant you a patent. Now, there's a huge journey between filing the application and having the patent granted.
Right.
So there's a lot of work and several years in that process, and the bulk of the money is actually after you file the applications with the patent office. Typically, not always, but usually patent officers will object to your applications, and then that's when you need a patent attorney to represent you and to work out the best way to get around the objections.
Okay.
Yeah. So if you're very ambitious with your patents, you could easily spend $100,000 or $200,000, on a complex bit of technology in multiple countries. That wouldn't be very hard to do at all. Yeah.
And that's each year?
No. That's it. Yeah.
Right.
Over the life.
It's a one-off cost.
Well, it's spread over many years. Yeah.
Okay.
Yeah, so, but if you were just interested in Australia, I'm not sure why you would be. No one's really interested in Australia per se. But it's the cost is much lower.
Right. That's the question I was going to get onto next. Is if someone took out a patent for just Australia or just the US, what if someone from Asia, copies it, develops it, and through the internet goes online and resells it back into the country? I mean, can so at this stage, if you took out a patent in Australia, for example, does that cover you for anywhere around the world, or is it only in Australia that covers you?
No, it only covers you in Australia.
Right.
So it would, if you filed a patent in Australia, that would protect you from people who are in Australia selling the product or offering to sell the product, people who are manufacturing the product, or people who are importing the product.
Okay.
Right. Importation of product can sometimes be quite tricky to stop, especially if it's a high volume, low cost product which is sold over eBay, for example. So it may not be if your product costs $2. I think it's going to be very hard. You might want trademarks can actually be a lot more helpful in that situation, because you can use if your product's trademarked, and if they're trying to import the product under the same trademark, you can actually have customs stop the product at the border. So that can be a lot more effective. But one strategy is that you could actually try and protect your invention in the countries where the other people might be manufacturing. So if they're manufacturing in China, you can try filing a patent application in China and then trying to stop at the source. So basically stop the manufacturing. So obviously that strategy is going to be more successful for some products than others. If you're building cars, it's going to be easy because cars are big and expensive. But if you're selling little tiny things and they're easy to move around or distribute or change factories, then it could be more difficult to enforce that sort of strategy.
You mentioned China. I mean, I don't know enough about it, but what I've heard is the whole patent and trademark within China is a lot more lax than it is anywhere around the world. Is that a fact? So if you had
there's a lot of infringement in China, especially of trademarks. They've got a big problem with luxury goods. I think there's issues with technology as well. But China has rapidly improved its IP enforcement regime. So now it's a very much possible to enforce patents and trademarks in China. And in some ways, they offer stronger, quicker protection than Western countries. So people like Derek Minhane at Cochlear, for example, is a big fan of filing patent applications in China because in his view, they can now be properly enforced.
Okay. You mentioned about the patent's all right, except if it's reverse engineered. Did I hear you say something, of that?
Yeah. So we're talking about secrecy there.
Right, right.
The whether patent protection or secrecy was a better approach to protecting a product. I mean, the thing about a patent is that the government will give you a 20-year patent only if you actually disclose quite detailed information about the invention in a patent specification, which is then open to the public. So you're basically giving away your secret recipe in exchange for a 20-year monopoly, and after that 20 years, that's it. You've got no more monopoly. So that's the downside of a patent. Whereas a secret, the plus side is that secret can potentially last forever, but it's actually quite hard to keep a secret, and someone else might independently come up with it. So that's the two trade-offs. But secrets are usually quite good for chemical processes, for example, where you can't actually tell. It's very hard to reverse engineer chemical processes, but electrical gadgets or machines or software, these aren't too difficult to reverse engineer. So you don't see secrecy often being used in the electrical areas.
For a technology-based entrepreneur, not only do they have to come up with that unique product and protect the rights of anyone copying that, but they've got to go out and find out if there's a market for it. And in being able to find out if there's a market for it, I imagine they're going to need to do some engaging of potential stakeholders to try and get a sense of whether that's going to take off. So
yes.
That's a real conundrum in terms of if they go out there and talk to people and say, look, what do you think about this? Is this something that you think has got legs? By the time, obviously, it's going to be a tricky situation in terms of going out there and doing a market research.
It is.
And protecting your turf.
It is, yeah. That's right. I agree entirely, and I think that's part of the part of your considerations, of when or if to get a patent. I know lots of people who think that you just have to speak to people, irrespective of whether you have a patent or not. You just have to go out and get ideas and bounce around ideas. And that may be the right approach in some circumstances. But you are giving away a lot, so you should really consider it. Not only potentially invalidating any future patents that you obtain, but patents are actually worth quite a lot of money potentially. And if you ever sell your company, your patents are one of the assets that your company has, and it's going to be one of the most valuable assets your company has. If you're an innovative technology company, your ideas are what give you your value, not the chairs and computers on the desk. So, do you really want to give up that value, which is your company's value in the future? You've got to be very careful about that. So the other thing is you may not have to give everything away when you talk to people. So maybe you can hold back certain key points, so that you don't give all your secret sauce away.
Given the fact that the patent's only valuable to the extent that someone much bigger than you, doesn't go out there and breach it, and then you've got to go out there and go after them, so to speak. Now, for a much smaller player, if a larger player went out there and breached those rules, how feasible is it for a smaller player to go out there and get down the legal path? So in that sense, our new entrants always at a disadvantage in terms of the fact that the bigger boys can go out there, look at the technology, even if it means slightly tweak it. So what I'm saying is, for a young entrepreneur, how could they try and protect that? Because if they've got to get down the path of pursuing that through legal channels, that would actually probably put them out of business anyway. So where's the fine balance between having a patent and protecting it, when competing against the big boys?
Yeah. Well, no, it's absolutely true. Startups can't afford litigation. That's extremely unlikely. I mean, litigation sort of starts from $50,000, but that's extremely cheap litigation. It can go to millions of dollars. So it's unlikely that a startup's going to have that sort of cash. Firstly, I'd like to just reiterate that patents can be instrumental in getting investment and funding. So, and that's why most people do get patents in the entrepreneurial space, and it's actually very rare to see an idea taken up very quickly by a big company. I think there's a few things about this that I'd like to say. Firstly, I mean, you do have patent rights. So, and if they infringe your patent rights, the rights are still there, and they last for 20 years. So, you may, if your company is successful and gets cashed up, you may eventually have enough to litigate on the back of a patent. So, there's plenty of time to sue infringers. And it's not necessarily you that's going to do the litigation anyway. If your product is if the product protected by your patent is very valuable, then you may find that someone else picks it up, like another gorilla, another big company. In which case, the company which is infringing your patent could be in trouble. So Nokia had thousands of patents in the smartphone space, and a few years ago they were sold for something like $5 billion for their package of patents. So for this reason, because companies like Apple wanted something to litigate with. So it's not necessarily you that's going to litigate. It could be someone who buys your company or buys your patents, or could be there are companies out there will litigate on a no-win, no-fee basis. They'll have a look at your case. I
was going to ask you that are there companies? I think Slater and Gordon at one stage used to do that on a success-only basis. So they would obviously pre-qualify. They perhaps get a sense of so because otherwise it's hard enough. I guess being an entrepreneur, particularly a technology entrepreneur, and I guess I'm trying to figure out to what extent is it if it's not a level playing field, an environment where the smaller player is not completely trodden over.
I think the right approach is to not litigate, and because the bigger companies are very hard to fight. They're very big companies, but I think little companies have got a big advantage, and that is they're extremely agile and quick, and they can move very quickly. So I think I'm not sure if a big company is really a threat in the short term. I think a small entrepreneurial startup company is actually in a much better situation to bring a new risky product to the market. And big companies aren't really going to be able to move that quickly. And maybe if your product's great and you move quickly, you'll get ahead, and the big companies will have trouble catching up to you until you're big enough to actually do something with those patents.
Sure.
So I think what you want to do is keep acquiring and protect patents that protect your technology, so that when the time comes, you've got this really valuable bunch of assets in your back pocket that you can use and negotiate with, and possibly sell, and if need be, litigate with. Truly, patents aren't a short-term play. You should really consider them long-term play. I mean, I've seen patents which have been litigated in years 18, 19 out of years 20. So right at the end of their life.
Wow.
So, technologies often take a long time to get to the market, 10 years or so, for some technologies or more. So, it's you shouldn't be thinking about a short-term strategy, I don't think. Yeah.
Sure. You mentioned when we were talking earlier, why would anyone want to have a patent registered only in Australia? It's partly because it's a much smaller market.
That's right. Yeah.
But, so do you do a lot of your work overseas as well? So, or is it?
Sure. The US is probably the number one market for patents for Australian entrepreneurs.
Mm-hmm.
Europe can be very popular, and China can be very popular too. In Europe, so the major big economies of the world are the as you'd expect.
Yeah, no, that's fair enough. So it's to do with the fact that there are a lot of consumers and individuals within those markets that the technology can leverage off from.
Well, it's not just that. I think the other reason why the US in particular is a very popular market is that we know how to do business with them, and they like new ideas, and we've sort of Australians sort of know grown comfortable with doing business with them and commercializing new ideas in the US. It's sort of a very good place to try new ideas, and to seek funding too. That's the other big thing.
Okay.
There's much more money available out of the US than Australia. Sure. And if you can go to the US with a US patent application, or even better, a US patent, and seek funding, you're in a good position.
Do you have a sense of whether how Australia fits in terms of the number of individuals going out there and starting their own businesses relative to what's happening in other parts of the world? I mean,
I think there are plenty of Australians that are entrepreneurial, and there seem to be a lot of startups around at the moment. There's lots of incubators about, and a lot of interest. I mean, traditionally, the big challenge in Australia is for entrepreneurs to find funding. That's number one, and how to fund their inventions. And generally, I've seen two successful models: either get money out of the US or bleed another business that the entrepreneur might have to fund their dream. Other sources of funding tend to be quite difficult to come by. The other big issue in Australia is that there are a lot of people with new ideas and starting their companies, but they reach a certain point in their commercialization, and they find it very hard to progress past that point. So there's a high failure rate in Australia. So those two things are problems that Australia faces, and these have been long-term problems. But having said that, I'd like to be a bit optimistic because the community is growing quite strongly, and I think these problems are going to diminish over time. I don't know how quickly, how fast they'll diminish, but I think a lot of these problems will fix themselves.
I was talking to an entrepreneur that had set up their own technology business, and one of the questions I asked was, would they recommend going cold turkey in the sense of stopping work and going full-fledged in trying to develop that, or would they consider continuing to work and developing that in the background? And one of the things he conveyed to me was, if the innovation, or if what the individual is pursuing has got a technology bent, and if they're working for a company that's within technology, they need to be careful of their confidentiality rules. And so if they were to develop that product, and if they went to launch it and the company claimed ownership of that might be very challenging. So in that sense, does that mean that if anyone's in the technology space, there's no scope for them to hedge their bets? They've got to pretty much go out there?
No, that's not true. Generally speaking, an invention belongs to your employer if you're employed to invent, and you invent it while at work, and it's in the area of your employer. It might be a bit grey there if it's in the area of your employer is interested in, but you do it out of hours. But generally, they can't actually legally claim ownership of your invention if it was done without any of their resources, and it was done in your own time. has nothing really to do with them. Having said that, I think it would be very smart to sort of clear it with the employer first, because if you get their permission, then that's going to solve a lot of problems later down the track for you, legally speaking, if there's any disputes, because you can always turn around and say, look, you gave me permission, and that pretty much absolves you from any issues there. So I think you should be quite upfront about, you've got some interest, and do you ask the company, do you have any problems with me working in this area?
Sure.
And hopefully they say yes. If they say no, then you've got other problems. If they say yes, and you keep a record of that, and you don't use any of their resources, you do everything at home, away from work.
Right. So you're saying just being transparent about that and putting that right up front, as long as it's within your own time.
And using your own resources, that's right.
That makes
that should be fine.
Right, because part of the reason why I've started this series, so to speak, is there are a lot of people in between jobs, being made redundant, working in jobs where they're completely dissatisfied with what they're doing, but they're in a rut. So there's not much work out there. But because they're in technology, there have to be a small bunch of individuals with ideas that they've never had a chance to crystallize and take that to a stage of formulating that into a business. And I would have thought that if there was a business incubator that helped individuals that had the idea but wanted to hedge their bets and perhaps work with someone that could help them build that bridge to where from the other end of the bridge that they land out from, it'd be a much quicker path to cash generation than them leaving their work, spending 6, 8, 12 months in trying to do that and eating into their capital. So do you feel there's scope for a business incubator that helps those in technology with an idea, that's sitting at the back of the head, and take it in terms of the development of a strategy to the advice in terms of whether the patent or not patented, and to help them with the business planning, the ability to go out there and make a pitch? Do you feel there's scope for a service such as that?
Sure, I think there's room for lots of different models in the market.
Mm-hmm.
Yeah. So I don't think that's a very crowded space at the moment. So I think that's not a bad idea. I mean, having started up my own business, it's not a technology business, but it is a business nevertheless. I think, and the same with any business, it just requires a lot of time and a lot of hard work. So I guess the only thing that has to be decided is whether it can be done with less time. But other than that, I think it's not a bad idea. Yeah.
Okay. Justin, just from a perspective of giving a flavor of what's out there, I think we've covered some reasonable ground. Are there any final words from your side in terms of if someone was contemplating heading into this space, what would be some of the advice or the guidance that you'd give them?
I'd say get advice quite early, and I think mistakes can be made very quickly at an early stage, which can really have big downsides, and those downsides can last a long time. It could even ruin the company. So, there's some simple things that can be done that can keep you out of trouble, and some advice can be given. And I think the other thing is that the advice for intellectual property protection has to be coupled with commercial advice. So you can't really divorce the two. If there's no commerce, there's nothing worth protecting.
Absolutely, yeah.
So you do need to seek commercial advice, and that can be from any source of any various number of sources. It can be from incubators, and if you're far enough down the track, you can try and get information from people like Accelerating Commercialisation from the Australian government, for example. And there's lots of sources out there. I think you've got to be a bit careful too about who you get your advice from. And so you should be asking around about other people's experiences with various advisors, because the quality is variable, and many of them have their own agendas.
Justin, if people needed to reach you, how can they reach you? So what's your website? How can they reach you?
Yeah, well, I work for, my firm is Phoenix Intellectual Property. So if they just Google that, they'll find my website and my contact details on it.
Great. All right. Thank you very much. I appreciate
it's been a pleasure.
giving me, Justin. Thank you very much for your time.
Okay. Thank you.